I'm Andrew Lidbetter, I'm a partner here, and I'd like to welcome you all to Herbert Smith Freehills this evening. I think it would be easy in a City of London environment to forget the difficulties that are caused by the Age of Austerity and the cutbacks which have been made generally and specifically in relation to resources to support the justice system. On that basis, we've been very pleased to be able to support the work of Justice. In particular, pleased to have the opportunity to sponsor Justice's Working Party in relation to the report on delivering justice in an age of austerity. And with that very brief introduction, I'd like to hand over to Andrea Coomber, the Director of Justice, to say a few words.
Thank you, Andrew, and thank you to you all for turning out on this sunny evening where I'm sure you'd rather be somewhere outside. This is a very important evening for Justice. I've been the Director for just over 2 years, and upon appointment I was asked to undertake a review of our strategy as an organisation. The strategy that emerged from that had two key features, both of which returned us as an organisation to our operation of old. The first was to refocus Justice on the operation of the justice system, civil, administrative and criminal, and to look at the rights of people within it. The second was to work more closely with our members, corporate and individual, and all our individual members who span the profession, from law students to the judiciary, tax partners to public law silks, and specifically to return us to working through working parties of our membership. Last March, the Lord Chief Justice launched our new strategy, and we quite soon after that decided that the first working party should be charged with coming up with creative, practical ideas for increasing access to civil justice. While LASPO and rising numbers of litigants in person provided an initial impetus, the reality was that for most ordinary people who never would have qualified for legal aid had already been priced out of the civil justice system. We wanted the working party to take a critical look at decision-making within the courts and tribunal service and import best practice from other fora and from abroad, and to put the needs of the users at the heart of its system. Sir Stanley Burnton kindly agreed to chair the group and Herbert Smith to provide support to it, and we're enormously grateful to Stanley and to HSF, which has had lawyers from all over the world working in advance of this report. We managed to attract a fabulous cross-section of our members, with over 400 years of legal practice between them. It wasn't mainly Paul Jenkins, but he did contribute. It's Geoffrey Bindman here, he's certainly up to the numbers. And for the last 12 months, they've been working really hard with our own Richie Parek, who I know Stanley will mention, to produce the report that's before you. I'm enormously grateful to the Working Party for all of their efforts, and to the many other friends of justice, many of whom are here tonight, who've shared their time and their insights with us. While Stanley will outline the conclusions, I should say that the Justice Council and the Executive Board are immensely proud of this report. It's very much in line with the great Justice Working Party reports of the past that dared to innovate and fundamentally shaped the justice system that we have today. We recognise that this report is just one first step towards a different approach to decision-making in civil disputes, and we very much look forward to working with the powers that be on its implementation in the months and years to come. Civil justice reform is one aspect of our work. Another enormously eminent group of our members are working on looking at complex and lengthy trials, including fraud, and that's chaired by David Calvert-Smith, who I think is going to be with us later on tonight. In the coming months, we're going to launch working parties looking at mental health in the criminal justice system, at privatisation and fair administration of justice, and in reform of the administrative justice landscape. I'm very, very open to ideas from anybody in this room on other areas of our system which might be worthy of our examination. One final thing, while this is a weighty report, as an NGO, justice is pretty fragile. We have a total budget of around £500,000 a year in the next financial year, and a small staff with only 2.5 lawyers, Ruchi being the half of a lawyer who we share with NYU. We desperately need to secure our financial future if we're going to meet the ambitions of our strategy, which is basically to become a King's Fund for the justice system. To this end, last October, we launched an appeal to raise £2 million in advance of our 60th anniversary in 2017. So far, we've raised almost £500,000, which is allowing us now to recruit a new lawyer to start working with us and a Silex apprentice, but we have a long way to go. At the back of the room you'll find information on the Justice Appeal. If any of you have secret pots of gold, please don't feel shy about sharing them with Justice. Equally, if you know of organisations or individuals who have their pots of gold and might be minded to support Justice, please do drop me a line. But tonight is about the Burnton Report, and with that I offer the floor to Sir Stanley Burnton.
Good evening, ladies and gentlemen. As I will be saying in a moment, to call this report the Burnton Report is a misnomer. The rule of law is an essential element of our democracy. It requires that the ordinary citizen who has a sustainable claim or who is wrongly sued can obtain justice. In the 21st century, a citizen may seek justice before a tribunal or from an ombudsman, but there are many cases that can only be resolved in the courts. In the 19th century, it was said that the courts were open to all, just like the writs. However, if anything, today it is easier for the ordinary citizen to go to the writs than to obtain legal advice or representation. Cuts to legal aid and the publicly subsidised advice centre mean that legal advice and representation, already costly, have become impossible to obtain for many. The result has been an explosion in the number of litigants attempting to steer themselves through an intricate and often intimidating justice system. The Justice Working Party was tasked with the question of how best to maximise justice for everyone, not simply those who can afford the cost of legal advice and representation. Some reports of working parties are essentially the work of the chair. That is not the case in relation to this report. Our working party consisted of highly qualified and experienced lawyers covering diverse areas of work. Our recommendations reflect the consensus arrived at after examining systems in this country and abroad. I would like to express our thanks and appreciation in particular to Herbert Smith Freehills for their generous support, the research they carried out on our behalf, and for their hospitality. And to our rapporteur, for want of a better word in Anglo-Saxon, Rushi Parek, who had the responsibility for the drafting of the report, setting out our conclusions and reasons. I think Andrea a moment ago referred to Rushi as half a lawyer, but she, in her work, has been 1.5 lawyers. What are the options? One Australian judge put it pithily, there are 3 things that can be done in relation to self-representation by litigants. One is to get them lawyers, the second is to make them lawyers, and the third is to change the system. As the title of our report reflects, we are currently in the grip of austerity Britain. We believe that legal aid designed as a constituent of the welfare state met a real need at a reasonable cost. Sadly, there is nothing in the manifestos of our political parties to make us believe that its availability will be improved during the foreseeable future. Reluctantly, therefore, we have had to assume that for that foreseeable future there will be no real increase in legal aid. But we recognise that litigants who represent themselves will always be institutionally disadvantaged in a system designed by lawyers for lawyers. Realistically, only the third option to which I've referred, that of changing the system, is viable. Initial inspiration for how this might be done came from the work of the successful ADR scheme employed by the Office of the Social Fund Commissioner, the work of the Financial Ombudsman, and the work of the Traffic Penalty Tribunal. They greatly impressed us. Applicants to each of these institutions cannot generally be expected to have legal representation. Yet under their schemes, each institution is able to decide large volumes of cases in a consistent and fair manner through the use of lower paid but expert and trained caseworkers. Senior decision makers oversee the process and adjudicate on the most challenging or groundbreaking issues. Our proposal for change adopts a similar approach. We recommend the introduction of a new actor within the justice system, a lower level, yet legally qualified, trained and empowered dispute resolution officer. We suggest calling this new actor a registrar, but to avoid terminological wrangling, we are not wedded to our proposed name. Far more important is the real potential represented by this new actor, however designated, to improve access to justice for ordinary people. In summary, we envisage that new cases will be considered in the first place by a legally trained court officer, the person we call the registrar. He or she will undertake active case management, proactively identifying the relevant issues, law and procedure, as well as any evidence needed to decide the case. In this way, the burden of drawing out the most legally relevant information in the case will no longer rest on the shoulders of the litigant. Our proposed registrar will also have an important second function, that of actively seeking to resolve a majority of the cases coming to the civil courts and tribunals. In any case where a defence is lodged, the registrar will have power to strike out a statement of case where appropriate, undertake an early neutral evaluation, or undertake mediation. Where none of these courses is likely to be effective or appropriate, the registrar will refer the case to a judge to be decided in the ordinary way. Referrals would include, for example, cases raising complex legal and factual issues, cases requiring oral evidence, potential test cases, or cases requiring interpretation of legislation or policy. This proposal builds on the innovation already taking place across courts and tribunals. For example, registrars are successfully carrying out case management functions in a number of tribunal jurisdictions. Similar trends can be seen emerging in the family court, the administrative court, and the Court of Appeal. Our proposals go further than anything currently being carried out. The refashioned justice system we envisage is one in which litigants in person are supported and guided, rather than, to borrow the vivid words of Lord Justice Briggs, treated as, quote, a problem to be managed away. Moreover, the registrar's dispute resolution function reduces waste by preserving relatively expensive judicial expertise for the most difficult cases. Our proposed changes can be further improved by learning from the example of other jurisdictions throughout the world. The Dutch, Canadian and Australian experiences demonstrate what can be achieved when the justice system is supported by accessible legal information, advice and assistance. Drawing on these examples, the Working Party has therefore also recommended the development of an integrated online and telephone portal. Aimed at guiding litigants through the reformed justice system, a comprehensive and accessible portal will go a long way to remedy the informational deficit which persists despite the commendable efforts of many across the legal profession. In the limited time available to me this evening, I've summarised the main proposals contained in our report, and I strongly commend it to you all. More than that, I hope I've been able to convey a flavour both of the serious concerns which prompted the Working Party to undertake our task, and our belief, having done so, that there is real scope to improve the current state of affairs. I should state that this report does not and is not intended to provide a complete solution to the widespread and complex barriers to access to justice. In particular, initiatives to defend and extend the legal aid budget remain critical. Even in our reformed system, we acknowledge some litigants will always need legal advice and representation. Our report on delivering justice in an age of austerity represents, in our view, an achievable framework for maximising access to justice for the ordinary citizen. To return to the theme with which I started this short speech, our proposals have real potential to ensure that the law's protections amount to more than a set of empty and illusory promises. Thank you very much.
It is wonderful to have an organisation in justice that is providing a real think tank. I think we have to appreciate that at this stage of the development of the United Kingdom, we need radicalism in the law, if those two words aren't self-contradictory, that we haven't seen for many, many years. We have to think back to the great reforms of the 19th century, when the county court was created, and when our criminal law was civilised. And I feel that we do face similar challenges today. And what I think is so wonderful is we have a body that is cross-party in its leadership, that is completely independent of any political organisation, and that has people who are devoted to spending time, and people who spend time who know what their subject is and can really bring an understanding and passion. So I welcome hugely, through this report, to which I wish to say just a few words in a moment, the new approach of justice. We owe Andrea and the Executive Committee and those who brought this change to justice about an immense debt of gratitude for this approach. Now, we all accept, and I think any politician would accept, that justice is central to our society. It underpins virtually everything we do. But there is no doubt it faces tremendous problems due to retrenchment and austerity. As we're in the middle of an election campaign, I will say no more. But as Sir Stanley has said, we have to find a way, and a new and better way, of looking at many of the traditional ways in which we have delivered justice. And I think what is very valuable is we've begun with what is important to the ordinary citizen, that is, giving them justice, which the courts currently deny them. Because there can be no doubt, if you were to ask anyone who was a lawyer and you've got a small dispute, do the courts provide a remedy? The answer is no. Because at low levels, and I mean low levels, if you go up to even what to many people is a fortune, the cost of our current system makes it unviable. And so I think what we've got here is a major way forward. When I gave the lecture to which Andrea has referred, I anticipated a very thought-through, very carefully structured series of proposals. I think what we have got has exceeded my expectations. It's well researched, it's well thought through, and it gives a soundly based approach for people to consider. The real challenge now is to make certain that the profession, because I think it's so important the profession understands the need, that the politicians actually have something in front of them that they can see will make a difference to people's lives, and that the public as a whole will see that the court and courts can actually, again, as they did in the 19th century, and as they did for much of the last century before we priced the courts out of the market, provide justice to provide a better life and a more secure life for many people. So I hugely welcome it. I think it's been an amazing achievement. And the only thing is, I hope all the other reports come will be as radical, if even not more radical, than this. And it would be invidious of me to pay tribute to the expertise, because it would take me too long in part, of the huge a number of people who've contributed to it. But one can be sure by looking at the list that one could not have found a finer collection of people with a greater diversity of interests and the courage to express radical views than those who are members of this committee. So thank you, whoever chose it, and thank you all of those who've contributed. But I wish finally, on all our behalves, to thank Herbert Smith, because I think that we must look at what does this mean in the context of the city. Some of us don't come here that often. Whenever you come to the city, I remember first coming to the city in the 1970s, and it was a city that was not like this. It was rather the only eating establishment. Essentially, it was Casey Jones's hamburger stand on Liverpool Street Station. The place was dead by about 6:15 at night, and there wasn't the wealth that there is today in any institution, let alone a law firm. And so I think it's wonderful that the law firms, who are so prosperous and are bringing so much money to the UK and other areas, are putting back, through their sponsorship of this kind of work, much into society, and actually showing that law isn't something for which you make a great deal of money in the city, but it's something that's central to all our lives. And I think the example set by Herbert Smith and by Andrew Ledbetter has been wonderful, and I very much hope that others will see that this is the way. Not only do we make justice central to our society, but actually make our lawyers understand there's more to law than making money, and there's more to London than international dispute resolution. There's law that is central to a just and democratic society, and there are few of our competitors who can say that. So can I say to you, Andrew, thank you very, very much for the sponsorship, to your young team who've done all this research, but above all to Sir Stanley for this hugely radical report. Didn't realise he was quite so radical. But thank you all very, very much indeed, but above all, thanks to Herbert Smith.
Do you want to thank the Chief and get the drinks happening again?
Thank you very much for those kind words. Thank you, Stanley, for running through the report. And everyone, do please stay for a drink, which is served at the back. Thank you.